I am delighted to welcome you on behalf of CIPIL. My name is David Erdos. I'm the director of CIPIL, and this is the first seminar of CIPIL in 2024. And I'm delighted to welcome Professor Paul Wragg from the University of Leeds, who is a professor of media law at Leeds, author of numerous works on privacy and press freedom, especially his Hart 2020 book, A Free and Regulated Press, which makes some very interesting and important arguments on press regulation. And you've also been interfacing with the Information Commissioner's Office on the Data Protection and Journalism Code, which will be quite a feature, I think, of Paul's talk, which will look at the Information Commissioner's role in realising a free and accountable press post-Leveson. So without any further ado, I will pass over to Paul.
Thank you very much. Thank you, David, for that very generous introduction there. Thank you very much to the audience members for coming as well. I have to say I wasn't expecting so many of you to turn out today, and certainly not to get into the thousands as you have done. Thank you also to the people online. You'll notice I can't tell where the camera is, which is why I seem to be just looking at my navel, which happens a lot as an academic. I'm going to talk to you today for around 45 minutes, depending on whether the clock I can see is actually working. Otherwise, it could be a lot longer. As David anticipated, I will be speaking about the ICO and its role, or potential role, in realising a free and accountable press. This is a subject that I have been fascinated by for a long time. It is an issue. Sorry, you can tell I can't multitask. Can't get my slides to work, David. Got a technical problem. So, what was I talking about? Press regulation. Now, press regulation is a topic that doesn't get discussed all that much. And when it does get discussed, it tends to be in dark and solemn terms as something terrible. As we may well remember the Leveson inquiry that took place in 2011 and reported in 2012. That's something that we'll be talking about shortly. But the difficulty in talking about press regulation, having a conversation about press regulation, is, of course, it tends to get a bad press, pun intended, because the people that we are talking about, the industry that we are talking about, have control over the terms of the debate, and they also have a very prominent voice in the political context. They have a very prominent voice in government. Some of them even occupy political roles. And that makes it very difficult to have a conversation in public, makes it very difficult to have a conversation in Parliament about press regulation in serious terms. Instead, what we tend to find whenever press regulation is mentioned in government circles, we have this kind of cartoonish debate in which we either get a kind of mythical sense of the press as this sort of noble enterprise that's constantly championing the underclass against the rich and powerful and the political, or we get, on the flip side, this idea that any kind of regulation is of itself some kind of doomsday event. In fact, in the aftermath of the Leveson inquiry, we regularly saw headlines that suggested that 300 years of press freedom had come to an end. It was no more. We would never get it back. what I've tried to do in my work is to try and argue that actually press regulation, when done well, is something that can preserve, in fact, has no impact on press freedom, because it's trying to tackle something completely different, which is press malpractice or press malfeasance. And since press malpractice isn't a feature of press freedom, the two can be separated into these distinct spheres so that we can preserve press freedom, but tackle press malpractice. So in the talk today, I'm going to talk about the question of why regulation is still important, why it's still topical. Now, for some of you online and in the audience as well, you may already be persuaded of this, that there is a need to regulate the press, or you may think opposite. But whenever I talk about Leveson, I'm very conscious I'm talking about events that took place over a decade ago. So it's important to reflect on why Leveson remains relevant and why there is still a pressing need to take press regulation seriously. So in the first part of the talk, I'll be trying to do just that and to say a little bit more about what press regulation means. The middle part of the talk will focus on the ICO's role in all of this. Specifically, I'm going to address a code of practice that is about to be issued by the Secretary of State through the ICO's office that will compel newspapers to take data protection seriously in the context of their journalism. So I'm going to talk about this code and what it looks like and how it might achieve the goal of meaningful press regulation. And finally, I will evaluate the prospects and think about whether, in fact, it is possible by means of the Information Commissioner's Office to realise meaningful press regulation. So that is a brief overview. I'm going to start with something that resembles the picture round in Have I Got News for You? As a man of red-headed tendencies, I do, as all men of red-headed tendencies do, I look to Prince Harry as a role model, a leader, and a hero. I will then move on to think about ipso. What I really should have done was to ask you what connects all three of these. But since there's so many of you in the audience, I'm just a bit worried that you'll drown out the audio. And finally, I will explain very shortly what connects and what these three recent events are. In the meantime, I feel I should just point out the credits for these pictures. The picture of the Dutch and the Duke and Duchess of Sussex there, kindly provided by Town and Country magazine. And the photograph of Parliament, courtesy of Barnes Coaches, on the fabulous multimedia tour. I have no idea what either of those two things were, but I thought it might get a laugh. And I was very wrong about that. So, let me commence by just thinking about regulation itself. Since press regulation doesn't get talked about all that often, it's not always known, certainly not in popular circles, just how the press is regulated, if it's regulated at all. Now, the word regulation is, of course, something that we're familiar with in an intuitive sense, but of course it means different things in different contexts. In every major industry, regulation tends to be normal, from teaching, although thankfully not university staff, but through teaching, through to light industry, through to the professional services, through to medical services. This idea of regulating professionals regulating to secure the interests of the environment, customers. All of these things are very familiar to us. We don't even question it. In fact, in a way, we sort of assume that industries will be regulated, that if there is a problem, particularly in a consumer context, there's someone that we can talk to who will secure our interests. And of course, in a media context, regulation is fairly normal because in the broadcast space, regulation happens all the time. Ofcom is charged with regulating, for example, the BBC and the other TV shows which we all pay for but never watch. Newspapers, though, are different. Newspapers have operated for the longest time on a voluntary regulatory basis. In fact, even before that, there wasn't any sort of sense of regulation in the newspaper industry. There has been a popular clamour for regulation of some kind, which has been driven by politicians since the late 1940s. There has been a sense that newspapers should be added to the list of industries that are regulated. And if they're not to be added to that list, then at least we should know why. So in the modern day, as of today, we have two press regulators. One is called IPSO, the other is called Impress. I'm going to focus on IPSO. IPSO, without any sense of irony, is an organization whose initials stand for the Independent Press Standards Organization. It is an organization that replaced the Press Complaints Commission, which itself replaced the Press Council, which itself replaced something else. That's it. IPSO arrived in the aftermath of the Leveson inquiry as a result of the recommendations that Leveson had made to the Houses of Parliament. And at the time, David Cameron said, unless those recommendations are ridiculous, of course, I will implement them. But then this is the same David Cameron who asked the question that he should have known the answer to, which is, do you want to stay in Europe? And so as with the Brexit debacle, sorry, I shouldn't say that, the Brexit success, I shouldn't just assume that all the members of the audience, both online and in person, were against Brexit, or that you all share my views of Brexit. And of course, it would be impersonal of me to ask which way you voted. But if anyone is offended, well, you know where the door is. Or perhaps you don't. I mean, it's not clear. And even if you got outside the other side of the door, it's not clear you'd know what to do. But David Cameron famously asked that question, and he famously stated that unless Leveson said something ridiculous, he would implement those recommendations, and he then didn't. From that, IPSO was created. IPSO was essentially a brand change for the PCC. It didn't really employ any more staff. In fact, it had more or less the same number of staff now that it had previously in its guise as the PCC. It didn't even move address. It's still in the same building. Membership of IPSO is entirely voluntary. And in fact, The Guardian, The Independent, and the Financial Times are not part of IPSO, and they sit outside the regime altogether. So the mainstream press has aligned itself with IPSO apart from these three outliers. New forms of journalism, particularly citizen journalism, has aligned itself with Impress. What's notable about IPSO, though, as compared to its predecessor, is that it has reserved to itself the power to fine newspapers for serious and systematic breaches of a code of conduct that newspapers themselves have devised and have signed up to and agreed to abide by. Now, two things are important about this event. One is the fact that this code is voluntary and reflects editorial standards, or is meant to reflect editorial standards, and that this code is itself aligned with the law, particularly privacy law, specifically the misuse of private information tort, which has developed in the UK since the year 2004. The other notable point, though, is that although IPSO has this power to investigate, it has yet to initiate that power. It is yet to initiate an investigation into standards at any of the newspapers which it regulates. What we can say, though, in IPSO's favour is that this is the most stringent, that is too strong a word, but it is the most stringent form of regulation for newspapers that has been seen in the UK at all. And as I alluded to earlier, there has been a continual progression towards this stronger form of press regulation since the first inquiry into press standards commenced in 1947. The question that remains, though, is whether this form of regulation is the final or ultimate form of regulation that we can expect. In other words, if we were to go further and have even more stringent policies in place, would we push the envelope too far and threaten press freedom? Now, at the beginning of this talk, I expressed confidence towards the idea of tougher standards of regulation. I said that it was possible to separate press freedom from press malpractice. And part of that confidence comes from the fact that the code, as I've already said, is one that newspapers themselves are responsible for, agree to, and which reflects standards seen in the law. But the problem that we have with press regulation is its voluntary nature. So one change that I would like to see is for it to become mandatory. Now, there is a vehicle available to us to achieve this, and that is the Royal Charter on Self-Regulation of the Press, which created an organisation called the Press Recognition Panel, which is independent from government, and which has the power and the mandate to oversee the creation of regulators. So IPSO put itself forward to the PRP to say, we would like to be a regulator. This is what we propose to do, and this is how we match the standards in the charter. And it was approved. IPSO refuses to subject itself to that kind of scrutiny. And there's a good reason for that, because despite protestations that it does follow Leveson's recommendations, in fact, when scrutinized, it doesn't. But if IPSO or some sort of regulator was compulsory for the press, then we have a vehicle to ensure that that regulator meets the exacting standards that we find in Leveson, and that would make the code of conduct that newspapers have agreed to, make it compulsory for them to follow, and for there to be real consequences in the event of a breach. The other problem at the moment is that when there is a breach of the code, the person affected by it can either go to court or go to a regulator. Now, to go to court is very expensive, as you are already aware. Tens of thousands of pounds are regularly expended just in bringing cases to court to protect rights to privacy, to protect rights to reputation. The alternative is, of course, for the Attorney General to take newspapers to court in order to protect the right to a fair trial under Article 6 of the European Convention on Human Rights. Now, of course, it is sometimes, so the alternative is to regulate. Now, it is often thought, particularly in the popular portrayal of the issues around press regulation, that the kind of person who complains is inevitably a person of some power, either a public figure in the guise of a public official or a public figure in the guise of a celebrity. Someone who has come into public prominence, who has deep pockets, who can afford to go to court. So why would we need to regulate? This is a fiction perpetuated by the press, but which is demonstrably a fiction when we look at the kind of complaints that IPSO gets, because invariably and inevitably, those complaints come from ordinary members of the public. Why should that be? Why would ordinary members of the public interest the press? Often there's two reasons. One, something embarrassing has happened to them, which makes for a titillating story, and so we have standards of privacy involved, or something awful has happened to them, some tragic consequence that causes them to experience grief or profound shock. Someone close to them has died. They've been involved in some kind of tragedy. That's how it finds its way into a newspaper. So when we look at the kind of claimant that we have going to IPSO, invariably they are not well-known individuals. They are not people that you've heard of. These are people who have piqued the interest of the press because of something terrible or embarrassing that has occurred. If they went and they had the resources to go to court, the law would protect them. But often they don't have those resources. So, I'll bring you back to this screen now. Why did I mention the Duke and Duchess of Sussex? Well, they've both been in the news recently because they both had successful claims. Unless you read the Daily Mail, which will tell you that actually the Duke of Sussex lost his claim. But for every other newspaper that you take, you'll know that actually the Duke of Sussex won his claim for misuse of private information through unlawful information gathering techniques, such as phone hacking, but also blagging and other private investigator type activity. And this claim related to the period of 1995 through to 2011, in which the court found that these unlawful investigative techniques and information gathering techniques had been in operation, not just in the period that we previously knew about, which was sort of 2006 to 2009, but actually all the way up to and partly including the Leveson inquiry, the public inquiry in which senior figures of these newspapers told the inquiry that unlawful information gathering was something that took place historically, but was no longer a problem. That was not the case, at least according to the findings in the Duke's claim. The Duke was a representative of a larger group of actions that were being brought against Mirror Group newspapers. There is another claim that is being brought against the Daily Mail. There were a series of claims that were brought in the year circa 2015 as well. All of these were successful and large payouts followed. The Duke himself was awarded £140,000. The Duchess was successful in 2021, possibly 22. I think it's 21. When the Mail on Sunday published a letter she'd written to her father. Her subsequent claim for misuse of private information succeeded. We've already talked about IPSO, but IPSO and the senior news figures behind IPSO have a very powerful voice in the Houses of Parliament, particularly in the House of Lords, where a lot of the press barons themselves have seats, and they are lords, which is something. There's something faintly ridiculous about that. In fact, the chair of IPSO is himself a lord, Lord Fawkes, and regularly sits in the Houses of Parliament, regularly addresses the Houses of Parliament. The recent event that is relevant here is that the press is pushing the Conservative government to repeal Section 40 of the Crime and Courts Act 2013. Now, Section 40 is a very complicated provision, which is essentially a cost-shifting provision that, in overview, would give cost protection in litigation to members of a recognised regulator. So the simple version, which is not the complete version, if you are a member of a recognised regulator and a claimant forces you to go to court rather than arbitrate through your regulator on a privacy claim or a defamation claim, you are indemnified against costs. The other side will have to pay, even if they are successful in court. But if you're not part of a recognised regulator, which of course all of IPSO's members are not, the reverse is true. You go to court, even if you succeed with your defence, you have to pay the other side's costs. So the press wants that outlawed, and of course it is a Conservative manifesto promise that they would do that, but it has been a Conservative manifesto promise since Theresa May, if any of us can remember that far back. Let me now turn to the code. I've given this code the big build-up, and hopefully you know something now about the context in which I am investigating the code. As part of the Data Protection Act of 2018, the Information Commissioner's Office was tasked with drawing up guidance and a code to police journalism for data protection infringements. The journalism industry, as you I'm sure know already, benefits from an exemption from parts of the Data Protection Act, where it is engaged in, for want of a better description, public interest journalism. There are a number of different factors that we'll look at shortly, but by and large, this exemption applies to them. Now, in a sense, that's unproblematic that they should be exempt from data protection law where public interest journalism is at stake, because in fact, that code of practice I referred to earlier also excuses them in those circumstances, as we shall see. But is the code adequate to replace the shortcomings of the regulatory system that we have, and to essentially make the ICO the de facto regulator of the press in circumstances where IPSO, through its poor performance, has demonstrated that it isn't? Well, the signs are good. I've taken this from the code itself. Look at the language here. This is from the This is the Information Commissioner's office, rolling up its sleeves and promising to take action to take this code seriously. Yes, it acknowledges the importance of public interest and freedom of expression, but it says, right at the bottom, we are committed to taking regulatory action against media organisations, just as we would any other organisation where it's necessary to ensure compliance with data protection law. Now, this is a really powerful statement of intent, which got me very excited. And that doesn't happen very often. The power or the provision that I alluded to a moment ago comes from section 125, paragraph 1. I've put it up here in all its glorious detail for a simple reason, to confirm that the guidance and the rules themselves perform two functions. There is a legal function. This is what must occur. And there is an ethical function. This is what you should do if you want to be a good media organisation that's living its best life as a protector of data protection law. This is something that you should do if you want to go above and beyond our expectations. And we need to be conscious of this duality, because this will impact on the way that the code is policed. And for those of you of a Kantian persuasion, you'll recognize the difference between the categorical imperative and the hypothetical imperative. In the code itself, the ICO is very clear on the difference between must, the categorical imperative of must, and the hypothetical imperative of should. And it says, to help you comply with the law, we say should when something is good practice, but it's not a legislative requirement. So we say should. If you choose to take a different approach, you must be able to demonstrate that your approach complies with the legislation. Then in 1.5, to help you understand what the law says, we say must in the code when doing something is a legislative requirement. Now, already in 1.6, I'm slightly uneasy in the apparent disconnect between the first sentence and the second, because to my mind, that's slightly confusing. You've said this is a should, but then you've immediately followed it up with a must. Still, we can read 1.6 through 1.5 and we get a sense of there's a difference between must and should. And all of that is lovely. It's misleading, but in a strict sense, it's true. The obligations in the Data Protection Act do relate to data protection law itself and what needs to be done to comply with the Data Protection Act. But where I think it's misleading, as we will see shortly, is that the language of should is itself applied to legal obligations rather than simply ethical ones. Specifically, when we look at the code, when the ICO starts talking about the misuse of private information tort, or rather the factors that we recognize from that tort, the language switches from must to should. Now, strictly, that's true because the misuse of private information tort is over here, the Data Protection Act and the GDPR is over here, and never the twain shall meet. But actually, the reality, as we know, is that there is a fine distinction, if there is a distinction at all, between the requirements of the DPA and the misuse of private information tort. It has been suggested recently, in fact, by Fiona Brimblecombe and Helen Fennick, that it's easier to bring a claim for breach of the Data Protection Act than it is to bring a claim for misuse of private information. So here is my proof, which I will rattle through, conscious of time. The misuse of private information tort, which I'm sure you know, has essentially two parts. To succeed in a claim, you need to demonstrate that you have a reasonable expectation of privacy in the information to be disclosed or actually disclosed. And once you've satisfied the court of that, there is a balance that takes place between the strength of your privacy claim and the strength of the corresponding claim, which in a media context is the public interest in that expression. So, reasonable to use personal information fairly, you should use it in ways that people reasonably expect, or you should be able to justify any unexpected use. That is not an accurate statement of law. You have to do this unless you want to be sued for misuse of private information. You should consider all the circumstances to decide whether using personal information is within someone's reasonable expectations. No, according to law, you must. Unwarranted harm, you should act proportionately. No, you must. You should be able to justify any harm. No. You get the idea. Sensitive types of information, you should always consider. When to take particular care, you should take particular care. I've alluded to this already, but when in the early days of the misuse of private information tour, people like Naomi Campbell and subsequently Joanne Murray, otherwise known as J.K. Rowling, brought claims for misuse of private information, they brought them alongside data protection act breaches. And the strong judicial finding in those later cases that has been affirmed in more recent cases is that if you are going to succeed in MPI, you're also going to succeed in a data protection claim. More recently, it's been put in the negative in Richard and ZXC, which is that, well, if you're not going to succeed in MPI, you're not going to succeed in data protection. Another way in which I think the Information Commissioner has not helped here, sorry, the ICO, I shouldn't blame the Information Commissioner himself, is naming a suspect in police investigations. They've taken this statement from the College of Policing Guidance, which uses the language of should. Suspects should not be identified to the media. But actually that is now a must. Both ZXC and Richard confirm that there is a reasonable expectation of privacy in naming or being named as a suspect under police investigation. And there are now mounting cases in which naming someone who has been arrested will lead to either an injunction or a successful damages claim. How long have I got left?
Oh, I don't. Well, at least all.
Oh, good. At the beginning, I thought, there's no way I'm going to speak about this for 45 minutes. Okay. When the ICO talks about the journalistic exemption under the Data Protection Act, we see the language of must reinstate it, which is good. To apply the exemption, you need to comply with these first four principles. Use personal information for a journalist. If you use personal information for a journalistic purpose and act with a view to publication of journalistic material, you've got to reasonably believe that it would be in the public interest and believe that you're complying with a part of data protection law. And you've got to reasonably believe that complying with a part of data protection law would be incompatible with your journalistic purpose. So this is not an easy exemption to satisfy, at least not on its face. Now, my perception, anecdotally, is that I don't think journalists always recognize quite how stringent the journalistic exemption is. My sense that journalists think because they're engaging in journalism, they therefore fall under the exemption and therefore don't have to comply with data protection law, full stop. So this provision in the code is very helpful for dispelling that illusion. And I think the severity of it is enhanced by certainly 13.5 here and 13.6, you must form and be able to demonstrate a reasonable belief. You must have regard to specific industry codes. But, and this is not criticism of the ICO, because this is part of the legislation itself, it's somewhat undone. The strength of the journalistic exemption is somewhat undone with the consideration that you, i.e. the journalist, must consider the general special public interest in freedom of expression and information. Now, I did query this at the time, where this expression had come from. What is a general special interest? Sorry, what is a general special public interest in freedom of expression and information? Because the Act doesn't use that phrase, general special. It doesn't use the word general. It does talk about the special public interest. But what does it mean? Where does it come from? What is this special public interest? And my concern here is because that phrase, the general special, if I'm to interpret it correctly, it rang a bell for me because I'd seen it somewhere before, and the average journalist will also find it to be familiar. And that's because when we, sorry, I should say 13.6, when we have regard to specific industry codes to work out what we're doing in a public interest context, we find this in the IPSO Editor's Code of Practice, specifically point number 2 there. There is a public interest in freedom of expression itself. So we have this long list. Number 1, public interest includes, and this list intuitively resonates with the idea of public interest journalism. It resonates with the idea of something that deserves an exemption from the strictness of the law, data protection law. But not 2. Because I don't think we even have to be insidious in our interpretation. I think naturally that expression, there's a public interest in freedom of expression itself, particularly when seen through 13.6 and 13.7, could lead the average journalist to believe that the mere fact of being a journalist is of itself a public interest that warrants or justifies the exemption applying. That's the danger of those sections taken together. So my hope is that the ICO clamps down on that. In fact, it's more than a hope. I specifically told them to do that. And they heard what I said and then promptly ignored it, which happens a lot, especially with my children. The problem here, I think, is that the Editor's Code doesn't balance privacy and free speech in the way that the law does, or at least it's meant to, through the misuse of private information tort. I'm troubled by further statements about the press and the press's role in a free society that also appear in the code, which may underpin this looser reading of what a general special public interest in freedom of expression looks like and what it counts for. Because we have this: a free media is at the heart of any healthy democracy, keeping us informed, encouraging debate and opinion, and entertaining us. It's a crucial part of the fundamental right to freedom of expression. A free media is also often called the public's watchdog because of its role in uncovering wrongdoing and holding the powerful to account. So a newspaper journalist, I think, could easily convince themselves that, for example, naming someone who has been arrested is of itself an example of this general special interest, this general special public interest, because it is this idea of, in the code itself, detecting and exposing crime, and using the ICO's words, uncovering wrongdoing and holding the powerful to account. But the law as it presently stands, through the misuse of private information tort, and by extension, data protection law, doesn't allow journalists to do that, at least not automatically. The code and the guidance are both silent on this point that I've just made. So let me now round off the talk. I'm looking at David and he's scrupulously ignoring me. By just briefly concluding about the prospects here of the ICO performing the kind of role that I would like to see a regulator perform in relation to the press. Holding the press to account for breaches of its own code in a way that allows the public to get a real sense of redress and justice without having to go to court. Now, the prospects, as I think I've alluded to, are favourable when we consider the independence of the ICO from both government and the industry itself. One of the problems with IPSO is that it still maintains a rather close relationship in its composition, in its connections to the industry. Senior figures are still lurking in the background. The Editor's Code of Practice, which erroneously I've described as the IPSO Editor's Code of Practice, isn't in fact IPSO's. The Editor's Code of Practice is drawn up by, is owned by, is managed by someone separate to IPSO. It is a board that is largely composed of existing editors, former editors. And although it has IPSO representation, they sit in the minority. As I also said, senior members of the press industry have close connections to government. There's a very cosy connection between the press and government. In Johnson's administration, if I can trouble you for a moment to think about that, his cabinet was largely composed of either current or previous politicians. George Osborne, for the longest time, was the editor of the Evening Standard. So the advantage of the ICO is its demonstrable independence from Parliament, politicians, and the industry itself. But does it have courage? Does it have the courage of its convictions? Will it stand up to the press? Will it take the press on? Is it prepared to go through with the rhetoric, or is it going to defer to the press? Well, why might I think this, given that there is nothing in the code that would suggest deference or a lack of courage? And sadly, the reason for that is because of what Leveson told us in the inquiry itself. The information commissioner from the early noughties, a Mr. Thomas, didn't regard the ICO as a regulator of the press. He thought that the press was regulated, if it was regulated at all, by the PCC, and it wasn't really his remit to investigate it. During the police investigation Operation Motormouth, which investigated Mulcair, amongst others, for illegally obtaining information from phones through hacking, he was very concerned and marginalised in a way by Parliament and also by the PCC. And when it was put to him by one of his senior officials that the role of the ICO was to take on the press, he is purported to have said, he does deny this, as you can see, he's purported to have said that the press was too big for us. We can't take them on, they're too big for us. Which the individual who reports this, Mr. Owens, amplified this in his evidence to the Leveson inquiry. The decision not to pursue any journalist was based solely on fear. fear of the power, wealth, and influence of the press, and fear of the backlash that could follow if the press turned against the ICO. And that fear, although we're now 20 years on, remains a live issue. Because although the printed press as an industry is in sharp decline, it still retains tremendous power and influence over government, the government of the day. There still remains a sense of the Victorian model, in which, when the franchise was very small, the Westminster Square Mile was where all the powerful decisions were taken, and there was a sort of tripartite agreement in operation between politicians, the press, and senior figures in industry, the strongest lobbyists. In the Victorian age, that was because that was basically where the franchise was located. We have the illusion of democracy, we should have the reality of democracy, and yet you will still find senior politicians now who are afraid to take the press on. We can attribute some of the actions of Keir Starmer to that fear, not to get a bad press in the Daily Mail, wherever else. So if we are going to realise a free and accountable press that can take on its role of being a public watchdog for every other industry, then we need a watchdog that's separate to the press to take on the role of watching that industry and making sure that it complies with its obligations. Thank you very much. That's enough from me.